Good evening,
Good evening, ladies and
ladies and gentlemen, esteemed, uh, esteemed participant and distinguished guest. It is with immense honor and profound respect that I stand before you today at Dr. Ashok Kumar Mohapatra Memorial National Moot Court Competition 2023. Today, we are privileged to welcome Uh, uh, Mr. Paras Padi and Mr. Mirza Aslam Beg, a distinguished judicial officer who has graciously agreed to adjudicate the round of our moot court. Their presence here is not an honor, but a testament to the high standards and the spirit of excellence that this competition embodies. On behalf of the Dr. Ashok Kumar Mahapatra Memorial Committee and all the participants, I extend our heartfelt gratitude and warm welcome to our esteemed judge. Your presence elevates this competition and inspires all to strive for the highest ideals of the legal profession. Now, with our Lord's permission, may start the moot court round.
Yes, please. Thank you. Sir.
May the council proceed?
Yes, you may.
If it pleases the honorable bench, may the council address the bench collectively as lordships. Your lordships, there are two PILs which have been clubbed together in this honorable Supreme Court. The one is Monica and Chandler versus the Union of Silverland, and the second one is One Code Movement versus Union of Silverland and Silverland Religious Group. If the honorable bench is well aware of the statement of facts, the council would proceed to the statement of jurisdiction.
Yes, you may.
The petitioners have approached to this honorable court under Article 32 of the Constitution of Silverland. My lordships, there are 5 issues in this case. The first 2 issues shall be dealt by this council, and the last 3 issues shall be dealt by this council's co-council. If the lordships allow, may this council start with issue number 1.
Okay.
My lordships, issue number 1 deals with whether both the PILs are maintainable in the Court of Silverland or not, and is it feasible to implement UCC in a nation like Silverland. My lordships, the PIL concerning same-sex marriage is very much maintainable in the Supreme Court of Silverland. My lordships, part 3 of the Constitution vests us with fundamental rights, and any breach of that fundamental rights gives us Article 32 as the remedy of this. The right to approach to this court is very much embodied in our fundamental right in part 3 of the Constitution. The court has the power to issue directions, orders, and writs for the enforcement of our rights. My lords, the doctrine of separation is very much well known to the whole country, but the judicial review is also a basic part and feature of the Constitution of Silverland, as stated in Keshwanand Bharti versus State of Kerala. Previously, it is not the first time the court is dealing with a case like this, where it has to give orders or writs or any judgments regarding this or guidelines. But previously, this very court has given guidelines in the case of Vishakha. And not only does it extend to striking down offending statutes or legislation, but also it has the right to issue suggestive directions to give effect to the fundamental rights. My lordship, it is very much within our locus standi, as the doctrine of locus standi talks about. Only the person whose legal right has been hampered can approach to this court, and the court has a right to bring action in that regard. My lords, this problem is not only concerned with Monica and Chandler, but it also concerns with the whole LGBTQ community, where the petitioners were not allowed to legally register their marriages by the Center Parks administrative bodies, which is a complete violation of their Article 14, 15, 19, and 21. Hence, this PIL stands very much maintainable in the Court of Silverland. My lords, the PIL, again, it was the question is the PIL concerning formulation and implementation of UCC. My lords, Article 44 of the Constitution vests with the constitutional obligation of the state to implement UCC. it is the council would like to address the very much constitutional debate, a part of constitutional debate by Dr. B.R. Ambedkar, which was said that a government which rests on the popular vote can hardly ignore the directive principle while shaping its policy. If any government ignores ignores it, will certainly have to answer to the electoral during the next elections. My lordship, it is under the state's obligation to work for the DPSPs, as DPSPs directly talk about the welfare of the citizens. This is the very concept of DPSP, and UCC here talks about the equality. It talks about treating citizens equally regardless of their religions. It was repeatedly said in the case of Shaira Bano, as well as other cases for the implementation of UCC. But the very letharginess of the state to implement UCC actually does not only contemn the court's order, but also contemns the constitution of Silverland. My lordships, the implementation of UCC will not only bring an equality, a sense of equality, but it will also reduce the gender inequality that is remaining in the state of Silverland. The Muslim women who are mostly facing the discrimination, that will be reduced to a very evident amount. Hence, the state ignoring the very ideals of DPSPs and its responsibilities towards a certain community is a complete misuse of its power. My lordship, the next thing which it asks is about the feasibility of the implementation of UCC.
Okay, counsel, before you proceed further, whether the DPSP is enforceable, whether can you get it enforced through this court?
My lordship, the DPSP is not a fundamental right, neither is it justiciable, nor is it enforceable in nature.
Right. So how can you approach this court for asking us to getting the DPSP enforced?
My lordship, it was very much said in the case of Balkan employees versus the Union of India, that the state can intervene in the policy making, that the judiciary can intervene in the state's policy making. And my lordship, here the implementation of UCC and DPSP concerns with someone else's fundamental rights. Hence, the state has a right to intervene in this very concept, as the absence of UCC, the omission of UCC, leads to the breach of fundamental right of a certain community.
What fundamental rights are infringed, basically?
My lords, they are denied to register their marriage legally. Not only that, they are also denied with certain other rights as well, which will be dealt by my co-counsel in the further.
No, but which of the fundamental rights is being violated?
My lordships, they are not allowed to marry. They are not allowed to adopt a child, nor are they allowed to claim a license money, which has been deposited by one of them. After the demise of one partner, the other partner can take that.
So allowing to marry or allowing to adopt is your fundamental right, or is it merely a legal right?
My lordship, it was under this court's jurisprudence that the statutory rights of this community was recognized. Now, currently denying of right to marry, there is no value of then legalizing the right to choose a partner or the right to choose union if you cannot give them a right to marry with that.
No, counsel, my question is simple. What you are speaking about is about a legal right to marry. My question is, which of the fundamental rights specifically is being violated by this not allowing you to marry or not allowing you to adopt? Which of your fundamental rights is being violated? Which you have come under Article 32.
My lordship, their fundamental right, Article number 14, 15, 19, 1 and 21 is violated under this, which I will be coming further. I'll be justifying each one of them.
Your co-counsel will be dealing with that, right?
No, my lordship. I will be dealing with this in issue number 2.
Okay, fine. So, why have you approached Honorable Supreme Court? Why not the higher courts?
My lordship.
Do you know the difference between 226 and 32? Article 32 and Article 226 of the Constitution?
Yes, my lordship, I have not approached to this High Court prior to the Supreme Court because, my lordship, coming to the High Court for justice, and when my fundamental right is breached, coming to the High Court is my fundamental right. But going to the Supreme Court is my fundamental right. The council pleads apology. Coming to the Supreme Court whenever there is a violation of my fundamental right is my fundamental right. Whereas High Court going to the High Court is not. Secondly, the council could have definitely gone to the High Court, but the council did enjoy its right of going to the Supreme Court under Article 32, and the court is vested with the rights to deal with it as well.
Undoubtedly, but you are saying that going to High Court under Article 226 was not your constitutional right. Is that your stand?
My lordship, no, my lordship. My concern is coming to the Supreme Court. If my fundamental right is violated, is well
within your rights. That is well within your rights. But when we are speaking about alternative remedy, then there is an alternative remedy available under Article 226 of the Constitution. Can you just say in brief, why did you prefer Article 32 rather than 226 of the Indian Constitution? Are you aware of Article 226 of the Indian Constitution? The Constitution of the Silver Land, which is derived from, which is pari materia with the Constitution of India. So are you aware with Article 226 of the Indian Constitution?
Yes, my lordship. The question that you asked is, why did I approach to the Supreme Court and not the High Court?
Right.
My lordship, the council seeks ignorance.
Fine. So the question preceding that is, are you aware of Article 226 of the Indian Constitution?
Yes, my lordship.
So how is it different from Article 32 of the Indian Constitution?
My lordship, Article 226 gives us the my lordship, the council is unable to recall it at this point of time. I apologize. The council pleads ignorance.
Fine. You will proceed.
Learned counsel, kindly tell me, just brief me regarding one particular point. Just take a second, think about it. You must have heard the Honorable Supreme Court time and again come up with the term Laxman Rekha, right? The Laxman Rekha of not intervening in the policy making.
Yes, ma'am. Yes,
what is the functions of the parliament? So what is your stance on the point that implementation of a uniform civil code through the judicial powers of this court would result in curtailing or taking away that power from the parliament, honorable parliament?
My lordship, there is no doubt that separation of power and the intervention of the court in this matter is a matter of policy, and where the court court is not supposed to do that. But my lordship, in the case of Balco Employees versus Union of India, it was very much regard, and it was very much said by this court that the court can intervene in the policy matters when it is considered with the benefits of the citizens. And my lordship, it is a part of judicial review to check on each.
Yeah. I just want to, just sum it up in one sentence for me, whether it is guideline that you seek or you seek the entire code to be, ordered through this code.
My lordship, what I'm saying is the court is vested with both the things. Even in the case of Vishaka, the court did not have any previous laws existing to that, but regardless of that, the court made guidelines. So accordingly, the court can make laws as well as guidelines and can also direct the parliament to act accordingly.
Okay, next. Continue, yes. Please.
My lordship, it talks about the feasibility of UCC. My lordship, the Constitution of Silverland upholds the principle of secularism. So, my lordship, another thing is Port Bay is one of the states in the very place of Silverland which has already implemented UCC in its own. So it will be a matter of very irresponsibility and prudence to say that it is not possible to implement UCC in the country, whereas a place in your country that has also implemented UCC. My lordship, UCC is a matter matter which has been omitted by the state. And the court has time and again said the state to implement UCC, but it has been very lethargic in that case. In both the cases of Sharla Mudgal and Union of India versus Union of India and Muhammad A. Khan versus Shah Bano, it has repeatedly said that UCC has been a dead letter in this country. But regardless of that, the parliament has remained silent about it, which breaches the principle of UCC, DPSP and the Constitution of India, as well as contempts the order of this court. And my lordship, the absence of UCC violates fundamental right under Article 14 of many communities, like the Muslim community, the women of that community are not allowed to practice polyandry, whereas the same Muslim man is allowed to practice polygamy, and many more things which Muslim women are susceptible to than other religious women. So it is completely a breach of Article 14. And this is happening exactly and totally due to the absence of UCC, which main goal was the unity and the treating equally of each of the citizen of this country.
Let's move on to the next issue. Right?
Indeed, Your Lordship. Your Lordship, issue number 2 deals with our issue number. Just a second, my Lordship. My Lordship, issue number deals with is same-sex marriage, regarding the same-sex marriage in Silverland. My Lordship, whether same-sex marriage can be recognized legally and does Constitution protect their rights? My Lordship,
First, sum it up in few sentences, right?
Yes, my Lordship.
Yes.
My Lordship, the absence of the same-sex marriage breaches Article 14 of the LGBTQ community. Article 14 talks about giving equality and equal protection to people, which is a fundamental right without any discrimination. And my Lordship, in the case of state of West Bengal versus Anwar Ali Sarkar, it was said that in order to give a different legal treatment, it must pass 2 tests of reasonable classification, that is intelligible differentia, and the second one is the differentia must be based on a rational connection to achieve sought to be achieved by law. My Lordship, excluding LGBTQ from this right or from the matrimonial statutes does not or fails to the reasonable classification under Article 14. Not only that, making improper discrimination to the LGBTQ community is a complete example of class legislation, of which Article 14 is completely against of. My Lordship, the concept of SMA was brought in this country for maintaining heterogeneity in this country, and the very concept of SMA talks about the marriage of two people, which was not socially acceptable at that point of time, or who decide to marry not under personal laws. And the mentioning of male 21 years and female 18 years in section 4C of the Special Marriage Act talks about that male and female should mean, my Lordship, male and female should here mean gender, the gender they identify with, and not exactly biologically constituted man or a woman. Hence, my Lordship, statutory recognition of fundamental rights of LGBTQ persons is a consequence of this court's jurisprudence. Therefore, denial of that is now the contravention of this court's jurisprudence only, and hence Article 14 is violated. My Lordship, not only Article 14, Article 15(1) says that the state shall not discriminate persons on the basis of sex. My Lordship, denial of the right to marry based on the sexual orientation of a person is a complete violation of Article 15, and it was, my Lordship, in the case of Navtej Singh Johar, the third gender were identified, but now you are not giving them a right to marry is a complete ironical statement. My Lordship, they don't even come under the prohibited relationships. Hence, Article 15, their violation of Article 15 should be a concern of this court, and the court must provide some solution to this. My Lordship, Article 19, which talks about the recognizing the rights of freedom of speech and expression. My Lordship, gender, my Lordship, it is a very necessary corollary, for the right to be expressing your own gender and your personal preferences regarding your life partner, but the unable to express their desires and wishes through speech, choices, etc. is a complete violation of Article 19. My Lordship, Navtej Singh Johar had also, in the case of Navtej Singh Johar versus Union of India, it was also said the right to form union. My Lordship, what is the role of union if you are not given the right to marry under this? Not only that, my Lordship, Article 20 talks about, in Article 21 also, my Lordship, if we categorically do not include this category of people, or we cite them, then it creates a public message that they are inferior to some other community in some other way, which will directly hamper their morality, my Lordship. And it was very much, the council would like to quote in case Puttaswamy versus Union of India, that it was recognized, this honorable court had been intellectual and wise enough to recognize the right to privacy and dignity and personal autonomy of and quality of life as facts of right to life and personal liberty under Article 21. In spite of that, no recognition of marriage to the queer community and the construction of Article 21 OTS for the queer community, which amounts to the blatant infringement of Article 21. Hence, the fundamental rights of fundamental rights under Article 14, 15, 19, and 21 is violated of the petitioners, my lordship.
Okay, counsel, as far as the first issue is concerned, just answer in 2 sentences. Number 1, when you say about Uniform Civil Code, don't you think that it will violate the Article 25 of the people who are saying that we have a right to practice a religion, and having our own personal laws is part of our right to practice religion? What have you got to say about it?
My lordship, the implementation of UCC will no way affect Article 25 and 26 of the Constitution, as it will deal with certain secular activities such as marriage, inheritance, etc. Yes, my lordship, that's it. And my lordship, another thing is this implementation of UCC will bring equality among people. My lordship, we cannot ignore the community which is being discriminated. Just
that can be done by the reforms in that particular law. Suppose if there is a problem, for example, prior to 1955, there were so many problems in the Hindu law. So we made a codified law. Hindu Marriage Act was codified because before 1955, even the Hindu laws allowed poly marriages. Right? So it was only after enactment of legislation in the year 1955 that there was a statutory regulation of those issues. So if your concern is that, then we can have some specific codified laws dealing with the particular issues of the particular community, and we can have specified laws, separate laws for the different communities. But when you are saying about Uniform Civil Code, so a contention which the other party in this case is raising is that their right to practice religion, because marriage, inheritance, and all those things are there, part of their essential part of the religion. So it will get affected. So how do you counter that?
My lordship, the constitution makers, when made this constitution and DPSP, they very much cleared that DPSP had a very concept of welfare of the citizens. My lordships, UCC comes for equality, my lordship. So we cannot my lordship, in the name of not in the name, my lordship, by saying it will breach Article 25 and 26 of the citizens, which is not true. We cannot ignore the equality part, my lordship.
So you are saying we should give precedence to one fundamental right over another fundamental right. Suppose we are, and equality is for equals, right? Equality is for equals. There are so many special legislation made. So we are saying now that equality is for equals. So far as the special legislation, similarly, we have personal laws which are giving special protection to the personal laws of the respective communities. So you mean to say that we should give importance to Article 14 and forget about Article 25?
My lordship, the law also talks about equal protection. So my lordship, here people are not protected. I think protection should be prioritized, my lordship.
Okay, that is a subjective view. Okay, now so far as your second issue is concerned, when you are saying about same-sex marriage, as my brother judge raised a very pertinent point. So what you are trying to say is we have so many laws, Hindu laws, Special Marriage Act. So those acts are defining who is a male, who is a female, and marriages. So are you actually asking us to legislate? Are you asking us to make laws? Because if we give any guideline, then we will be overstepping our boundaries, and we will be like making literal amendments into the definition of marriage, into the definition of the relationship, male, female, and all those things in so many laws. So how do you justify that on our behalf?
My lordship, here male and female should mean the gender they identify themselves with. I am not saying that we should amend things, or my lordship, that is not needed. But here the fact that male and female should be what they identify themselves with. Not
that is your opinion, but the will of the people says that male is a biological male. The will of the people, which is reflected to the acts amended or acts which are drafted by the parliament, they are defining marriage, male as a biological male, female as a biological female. So what is your view is that if we sitting like in division bench, we two judges, I don't think it would be proper on our part to overstep our boundaries and to have our overreach over the will of the people and just change the law by just a judgment.
My lordship, the will of the people, my lordship, when this Hindu code bill was passed, it was not supported by many people as well. But we got 4 legislatures after that from it. So the will of the people is a very secondary thing. Rather, the judiciary and
No.
the legislature is wise enough to take decisions what is for the welfare of the people. My lord, will of the people is a very ephemeral thing here.
Customary rights should remain, or the Uniform Civil Code should
My
do a
lordship, yes, my lordship. The thing is, when the UCC will be made, obviously they will keep an eye that certain things are respected, which ought to be respected in all the spheres.
that all religions have their own customs. Yes.
Yes, my lordship.
So how can we integrate them at one place?
My lordship, by properly reviewing their customary things. My lordship, this Muslim law, many things were also amended in Muslim law and Hindu law as well for the welfare of the people only. Many people might have been obstructing certain things that have been changed at that point of time, but still this honorable court did that in the welfare of the country only.
So Balco case you were citing, can you just say the brief facts of that case? Because you are citing that again and again and asking us to cross the Lakshman Rekha. So are you aware of the facts of this case? Can you just tell me in 2 lines what are the facts of the case and how is that applicable to the present case?
My lordship, which case could you
Balco case you were citing, or Visaga case? I'll just give you an option. Just you can say brief facts of, or just tell me the topic on which the case was relating. We are running short of time. You just tell me that this case was Balco case was relating to this issue and Visaga case was relating to this issue.
My lordship, in the my lordship, in it was the guidelines were framed about the this protection from sexual harassment in working places in this case.
Visaga case,
and it was held, and there were no prior guidelines or laws relating to that.
Fine. And what about Balco case? Balco case?
My lordship, the council pleads ignorance in that aspect.
Fine. Okay. Thank you.
My lordship, if my lordships are content with the submissions of issue number 1 and 2, my co-counsel shall deal with the rest of the issues.
Please, please.
It was an honor submitting before this honorable court. Thank you.
Thank you.
Your Lordship, the council would seek the permission of this honorable bench to begin with issue number 3.
Please,
you may proceed.
Much obliged, Your Lordship. Your Lordship, Uniform Civil Code doesn't infringe the fundamental rights and personal rights of the people because it is the duty of the legislature state to secure and has the competency to do so. Moreover, it was said by Justice Y.V. Chandrachud in case of in Shahbanu case that Uniform Civil Code shall act as a cause of national integration by removing disparate loyalties to the laws which have conflicting ideologies. Your Lordship, Uniform Civil Code will also does not infringe the fundamental right under Article 25 and 26, as it was held in Sarla Mudgal versus Union of India that marriage, succession, and like matter of secular character cannot be brought within the guarantee enshrined under Article 25 and 26. And Article 25 protects the fundamental rights to practice and rituals and ceremonies which are only integral part of the religion. Hence, they do not apply in the instance case. And from the same reasons, that Article 26 also won't be applicable in this case. Moreover, Lordship, the Uniform Civil Code does not infringe upon the personal rights of the citizens, as we can talk. I would like to cite the doctrine of construction harmonious, which states that whenever in an enactment, two of these provisions are in conflict with each other, they should be constructed in such a manner that they strike balance within both the same. And the harmonious construction of DPSP and fundamental rights can help the legislation to achieve its goals, that is the public interest and welfare, as held in Muhammad Hanif Qureshi and others versus State of Bihar 1958, that these directive principles are fundamental in governance of the country and it is the duty of the state to give effect to them. Moreover, in S.R. Bomai versus Union of India, it was held that religious is a matter of individual faith and cannot be mixed with secular activities. Thus, secular activities can be regulated by the state for enacting laws. Your Lordship, if the Honorable Bench is convinced, the Council would seek the permission to address the issue number 4.
So far as the marriage is concerned, marriage is associated with the practice of religious practices, right? Marriage associated with religious practices, right? For Hindu marriages, we have separate procedure. For Muslim marriage, we have separate procedure. For Christian marriage, we have separate procedure. So how do you say that marriage is a secular practice?
Sir, Your Lordship, marriage is of it is like a marriage or character of secular character, because we can say the objective and the purpose. Like it's a union of both the sexes, and the purpose is that to create such an instance where both the partners can live together. We cannot ignore. We can have different ways. Like in Hindu, we have that the ritual of Saptapadi, and in the Muslim law we have different. But the objective that is that the union should be in such a way that two partners could live together, and such there will be it also the stability within the family and the growth of the family. So we cannot say that if it's a secular character, there is no differentiation among this.
So if we propose for UCC, then what do you suggest, that whether it should have the elements of the Hindu law or it should have the Muslim law?
Your Lordship, the Uniform Civil Code should be constructed in such a way that it does not infringe any of the beliefs of the minority, and it does not create a fear of sense of fear that the laws of majority can become the laws of land. However, it can be constructed to in a way that the harmony and peace is maintained.
Fine.
So the question of on the question of divorce, that marriage, sometimes there is divorce.
Yes, Your Lordship.
There is a lot of talk regarding the different kinds of customs that are prevalent in various religions with respect to not divorce per se, but talaq in Muslim, and then in Hindu law we have to go through divorce by court, right?
Yes, Your Lordship.
How will you just tell me in one sentence, how can we just bring this in one ambit under the Uniform Civil Code?
Your Lordship,
harmony, right? Harmony, and
yes,
nobody's affected. Just tell me in one sentence. What is the right way to deal with it so that the Uniform Civil Code would work?
Your Lordship, the provisions related to divorce could be constructed like it won't be neither much rigid, not much flexible to go through the grounds of divorce. Like in section
should be between the parties.
Your Lordship, sorry, pardon, Your Lordship.
It should be through court, enforced through court, or it should be between the parties. Like as in Muslim law, it can be done.
Your Lordship, it would go through court.
That's the majority view. Won't the minority be affected by it?
Your Lordship, no, the minority won't be affected in such a way, because we are constructing it is not only for minority, it is also applicable to majority as well.
So because the very essence and definition of marriage, as my brother judge was asking this question, as per Hindu law, it's a sacrament. So sacrament cannot be broken easily, and that is why we need intervention of the court. Right. In fact, Hindu law in itself did not have any provision for divorce. It was only after Hindu Marriage Act we got divorce as a concept. Divorce, there is not even a term in Hindi proper term in Hindi for divorce. So that concept is completely alien to Hindu culture. But so far as Muslim law is concerned, marriage is a contract. That is the essence of marriage. That is the definition of marriage in their religion. So far as the contract is concerned, it is an affair between the two parties. So there the involvement of third party is not required. So how do you deal with it? Whether we should treat it as contract or whether we should treat it as sacrament, or whether there is a middle path there?
Your Lordship, the approach should be to find a middle path, because Your Lordship, if we talk about some of the provisions, earlier it was the provision of triple talaq. Your Lordship, triple talaq used to deal that if a husband says talaq 3 times, it would means that the divorce is done. Your Lordship, if such a provisions would have existed till today, there would be a violation of right to equality of the woman as well. And we cannot say that such a contract would be valid. Rather, now if we are specifying the grounds upon which the divorce could be enacted, we are specifying, and we are also the rate of divorce as well as the parties so constituted could also get their rights. It would protect their rights as well.
Move on to continue, please.
Your Lordship, the Council seeks the permission to deal with issue number 4.
Yes. Proceed.
Much obliged, Your Lordship. Your Lordship, the refusal to give adoption for LGBTQ couple is a violation of their right. It is violative of Article 14 as it is arbitrary, Article 15 as it is discriminatory, Article in Article 21 as Adoption Regulation 2022 does not qualify as a valid procedure established by law. Your Lordship, it is a violation of Article 14 as Section 57 of Juvenile Justice Act has no such specification as to whether only a marital couple could adopt. But Section 5, subsection 3 of Adoption Regulation mentions such a specification, making it ultra vires of Juvenile Justice Act. And Your Lordship, here the judiciary plays a crucial role in clarifying the ambiguous through a liberal and purposive interpretation. Your Lordship, the adoption regulation needs to be interpreted in such a way as to include homosexual couples. Moreover, Your Lordship, there is no rational nexus between such a classification and objects sought to pursue, because such a narrow interpretation of Juvenile Justice Act is solely based on differentiation, is only based on the sexual orientation of the LGBTQ community. Therefore, the classification does not serve the basic purpose or objective sought to be achieved. Your Lordship, it is also violative of Article 15 as such a differentiation between homosexual couples and heterosexual basis is solely based on their sexual orientation, and such a regulation is violative of Article 15. It is also violative of Article 19(1)(a), as in case of National Legal Service Authority versus Union of India 2014, this Honorable Court held that the expression of gender identity is a form of protected expression under Article 19(1)(a). And this regulation, and under this particular regulation, it is solely based on sexual orientation, and hence the restriction is arbitrary. Your Lordship, and the refusal to give adoption is also violative of Article 21, as Adoption Regulation 2022 does not qualify as valid procedure established by law. Your Lordship, in Menka Gandhi versus Union of India, a decision was held that any law interfering in the personal liberty of a person must satisfy a triple test. It must prescribe a procedure. The procedure must withstand one or more the fundamental rights under Article 19 as applicable to the situation, and it also must be liable to be tested with reference to Article 14. Your Lordship, the Juvenile Justice Act, ultra vires parents, the Adoption Regulation 2022, ultra vires Parents Act, Juvenile Justice Act, and hence there is no valid procedure. Moreover, it has already been proved that it also fails the dual test of reasonability and does not pass the reasonable classification. Hence, Adoption and Regulation Act does not qualify as a valid procedure established by law. Your Lordship, if the Honorable Bench is confessed, the Council seeks permission to go to the next issue, issue number 5.
Your time is over, so just cover the final issue in just very short, briefly.
Yes, Your Lordship, much obliged. Your Lordship, it is humbly submitted that the denial of LIC claim is a violation of Monica's fundamental rights under Article 14, 15, and Article 21. It is violation of Article 14 because when Insurance Act and concept of insurable interest was introduced, there was no such concept of homosexual or unmarried couple. However, with the passing of time, such a couple had entered, and by the doctrine of updating construction, it must be construed in such a way as to include homosexual couples. Your Lordship, it is also violative of Article 15 as such classification is solely based on the sexual orientation of LGBTQ community, and further it is also violative of Article 21 because it is in this impugned case the denial of LIC claim situates Monica in such a position as she would not be enabled to meet her financial requirements. Hence, it interferes with her quality of life and violates a right under Article 21. Your Lordship, If the honorable bench is satisfied with the submission of the counsel, may the counsel proceed to the prayer.
Counsel, LIC is not denying the claim on the ground that it is an LGBT couple, right? That is a issue which is separately dealt with, which was dealt with in the issue number 2. LIC is denying the claim on the ground that what is the ground on which? Yes, you are not having
marital certificate.
You don't have a marriage certificate, right?
Yes,
so you need to satisfy that how in the absence of marriage certificate, another person can be a stranger, can be a nominee, okay, or a spouse not having a marital certificate, she can claim a right to the LIC amount.
Your Lordship, denial of marriage certificate is also.
Was it not wrong on the part of Chandler to write Monica's name under the spouse heading? I mean, like category.
Yes, Your Lordship, he would have written, but in the subjects, in this instant case, the fact sheet is silent about this.
Okay. Is it necessary, as far as your awareness of the LIC policy is concerned, is it necessary that an insurance nominee can only be a spouse?
Indeed, Your Lordships.
So apart from spouse, any other person cannot be a nominee under LIC?
Yes, Your Lordship.
Okay. Move on to the prayer, please.
Much obliged, Your Lordship. Whereof, in the light of issues raised, argument advanced with and authority cited, it is humbly prayed that may the Honorable Court be pleased to uphold that the PILs are maintainable before this Honorable Court, declare that it is feasible to implement Uniform Civil Code in Silverland, declare that Uniform Civil Code, being a constitutional mandate, needs to be implemented, declare that refusal to give adoption rights to Chandler and Monica is a violation of their fundamental rights under Article 14, Article 15, Article 19, and Article 21. Uphold that denial of LIC claim to Monica infringes her fundamental rights guaranteed under Article 14, Article 15, and Article 21, and pass any other order, direction, or relief that this Honorable Court may deem fit in this interest of justice, equity, and good. And for this act of kindness, may the petitioner duly shall ever pray.
Thank you.
Okay, can we proceed with respondents?
Please, sir.
Yeah, respondent, please.
If it may please your Lordship, this counsel representing the respondents seeks permission to address this bench collectively as your Lordships.
Yes, please.
Much obliged. Your Lordship, the present case involves two public interest litigation applications that has been filed under Article 32 of the Constitution of Silverland and has been clubbed together by this Honorable Court for adjudication. If your Lordship are well versed with the facts of the case, the counsel seeks permission to move to the issues raised.
Yes, please.
Much obliged. Your Lordship, there are in total 5 issues, out of which issues 1 and 2 shall be dealt by this counsel and the other issues shall be dealt by my co-counsel. Your Lordship, the counsel seeks permission to start with issue 1.
Yes, you may.
Much obliged. Your Lordship, in furtherance of issue 1, which has been the issue of maintainability of both the PILs in this Honorable Court and whether it is feasible in the application of Unified Legal Code in a country like Silverland, this counsel most respectfully submits that, Your Lordship, this is a case of private interest which has been wrongfully subsumed to be one of public interest. And moreover, there is no sufficient interest of the petitioners to address this honorable court. The Supreme Court has many a times flagged the issue of thousands of frivolous public interest litigations that have been filed in lieu of public interest, but have also again found to be of private interest. Your Lordship, the Supreme Court has already allowed the marriage of heterosexual unions of relations of transgenders under the case law, under the present laws of marriage in the case of Suprio versus Union of India, WPC number 1011 of 2022. Hence, Your Lordship, in this case, the petitioners Chandler and Monica fall under the spectrum of transgenders. Chandler is a trans man and Monica is a trans woman. Hence, it is the case of recognition of their own marriage, which is denied by the authorities. And Your Lordship, on denial of this, they have an alternative remedy to file a writ of mandamus as a writ application in the High Court of Centraburg under Article 226. Hence, Your Lordship, this is clearly a case of private interest, which has been wrongfully assumed and subsumed as public interest. And hence, Your Lordship, this petition is not maintainable. Your Lordship, the right to adoption and right to marriage have not been recognized by the administrative authorities. And moreover, Your Lordship, the right to adoption and the right to marry are not fundamental rights. And hence, they are legal rights which can be enforced by the High Court under Article 226. Your Lordship, the state by Your Lordship, dealing with the issue of feasibility of UCC in the state like Silverland. Your Lordship, Silverland is a country which has deeply rooted traditions. It inhabits different religions of people, not only a single faith, but Hinduism, Muslim, Islam, and there are established personal laws relating to different religions, Your Lordship. And the state, by virtue of entry 5 of list 3 of 7th schedule, has the power to regulate the institution of marriage, Your Lordship. The courts cannot issue directions granting legal recognition to non-heterosexual marriages because it would require the redesigning of several enactments and rules, Your Lordship. And hence, the other PIL filed by One Court Movement is also not maintainable, Your Lordship. Moreover, Your Lordship, Silverland is a country which has a mixture of personal laws. Some of the laws have already been codified, and the societal complexities doesn't make it feasible for a unified legal code to be applied in Silverland, Your Lordship. And Your Lordship, the learned counsel of the petitioners have taken the example of Porto Bay. But Your Lordship, Porto Bay is in parimatria with Goa state of India, Your Lordship. And it has been found that the unified civil code that is applicable in Porto Bay has many places where it has left the legislations to personal laws. Like there are many provisions which are not actually uniform. Your Lordship, there has been many, the Catholics and Hindus, they enjoy different privileges as to marriage. The Catholics enjoy the privileges, they have an exemption from marriage registration, and the ability of the Catholic priest to dissolve marriages is also there. The Catholics can solemnize their marriage in church after obtaining a no objection certificate from the civil registrar. For others, the other religions, only a civil registration of marriage is only accepted as proof of marriage, Your Lordship. And Your Lordship, even in that unified civil code, there are the adoption laws are also not same. The laws are also not same for adopted and illegitimate children, Your Lordship. And hence, and moreover, Your Lordship, the population of Goa, that is very less in comparison to Silverland. The Porto Bay, that is in parimatria to Goa, that is very less in comparison to Silverland. Hence, applying a unified legal code in a small area is easily possible, Your Lordship. And Your Lordship, the learned counsel of the petitioner have also said that the state must answer the people in the next electoral. The state must answer, right? So the state has to take into view the mindsets of the people and the will of the people while construing a unified legal code, Your Lordship. Hence, it is not feasible, Your Lordship, to apply a unified legal code in Silverland, Your Lordship. The council.
Council, yeah, you first think that this is not involving any public interest, but their very prayer is that the same-sex marriage should be declared as valid. How do you say that it is not involving public interest? Because there are so many persons belonging to LGBT community, and they want that same-sex marriage should be recognized.
Indeed, Your Lordship. But in the present case, the petitioners, they are under the spectrum of transgenders, Your Lordship. They have filed for the recognition of their marriage. They have been denied for registration of marriage and right to adoption, Your Lordship. They have
the facts may be very personal to them, but if you are aware of the facts, the fact sheets say that obviously they have come before this court seeking recognition of their marriage, but they have a specific prayer, as mentioned in the para 8 of your fact sheet, that they have come with a specific prayer. Number 1, to recognize unified legal code, and number 2 is with a specific prayer to declare same-sex marriage as valid. So we are concerned with the prayer which they are making, which is indeed involving public interest. So how do you say this prayer is not involving public interest?
Indeed,
any public interest, definitely it arises from some personal problem which they may have, but had the prayer been very personal specific, then we could not have entertained it as PIL, right? But their prayer is going to affect interest of so many persons, or public at large. So how do you say that it's not PIL?
Indeed, Your Lordship, but the petitioners, they do not have sufficient interest in the PIL because their marriage has already been validated. In the superior judgment, Justice D.Y. Chandrachud had already stated that marriage of heterosexual unions of transgenders is allowed under the prevalent laws of marriage, Your Lordship.
Fine, you can proceed.
If Your Lordship are satisfied with issue 1, the council seeks permission to move to issue 2.
Please.
Much obliged, Your Lordship. Your Lordship, the issue 2 involves whether UCC infringes the fundamental and personal rights of the individuals and whether the state overreaches the personal rights of the individuals. Your Lordship, different traditions, they view marriage as sacraments and indissoluble unions, as in Hindus and Catholic Christians, but Islam regards marriage as both contractual and sacred. Parsis regard it as a sacrament and contractual. Most importantly, they base it on procreation. Hence, the their differing views as to marriage makes it very complex to create a balance between all the religions. And moreover, Your Lordship, they are already been codified laws. If UCC is implemented and more in validating the same-sex marriage, UCC implementation in validating the same-sex marriage, if same-sex marriage is included in a UCC, then that will create a setback, because the other laws like the Hindu Succession Act and they will be unworkable, Your Lordship. Because in Hindu Succession Act, section 21A, the rules of succession say that they are applicable to marriages of male and female under the Hindu Marriage Act. And so if the same-sex marriage are included, then that will obviously violate that will make the Hindu Succession Act unworkable, Your Lordship. And moreover, Your Lordship, there is a right to religion that has been given under the Constitution of Silverland to all the people to practice and profess their own religion. Your Lordship, the cultures, these are not something of new. They are very historically rooted in Silverland. And hence, every religion has different cultures, Your Lordship. And every religion, the members of every religion have the right to practice the norms and the cultures of their religion, Your Lordship. And implementing a ULC right now with the present societal norms and societal reservations, that is very difficult, Your Lordship. And Your Lordship, the Unified Legal Code affects the fundamental rights and also personal rights in making the marriage and divorce laws. Your Lordship, Silverland is a country where the ruling body, the present ruling body, is inclined towards the majority faith, Your Lordship. And the minority rights may not be, they have a fear that the minority rights may not be properly established and properly given in the ULC. And hence, there might be an infringement of the minority rights, Your Lordship. And there has been also very much undermining of the Muslim laws, Your Lordship, making it anti-women. And because the Muslim law has in many provisions given equitable rights to women, Your Lordship. That there is a provision of divorce for Muslim women. There is the provision of meher, and not exactly the Muslim law is unequitable to Muslim women and Muslim men, Your Lordship.
What
And the
about
state,
polygamy? What about polygamy? Polygamy is allowed in Muslim law, and your fundamental right to practice religion is subject to whether the right to practice religion is absolute or it is subjected to certain restrictions. Can you say what are the restrictions which right to fundamental practice religion is subjected to?
Your Lordships, as far as the council knows, the restrictions are that your practice of religion, practice and profess of religion must not violate the practice of religion of other communities.
No. The section Article 25 starts with subject to this. Article 25 does not start with right. Article 25 starts with restriction.
Indeed, Your Lordship.
Right? So unless you are crossing that limitation, or unless you are able to justify, you are passing the test that this particular practice in the religion is not subjected to these things. So can you specify that? Now you can...
Your Lordship, public order, morality, and health, and
right.
to the other provisions of this.
Fine. So far as polygamy, principles such as polygamy is concerned, so don't you think that it is against the morality, public order?
Your Lordships, the present societal norms are in a slow pace moving towards the generalization of monogamy. The people are right now they have not obtained that growth of development, but yes, they are in a pace of movement towards a monogamy country. So Your Lordship, that
so are you saying that we should wait for people to change and then the law should be enacted? How does it work that people will change and the law will be enacted, or law will come and it will change the society?
Indeed not, Your Lordship, but the people's will also matters, Your Lordship, because if majority of the people don't agree with the laws, then how can the law function? There will be the state cannot maintain public order, Your Lordship, by that.
So for majority of, if the will of the people is against public order, public morality, so should we allow it to continue?
Indeed not, Your Lordships, but there can be various other provisions like changing the morality. Your Lordship, during the abolition of sati, that was also against many people, but that was changed by changing the thought process of the people. That is a process that will take time, Your Lordship, and presently it is not feasible, Your Lordship.
Okay, so I'd like to know, just one small reply from your good side, right? Keeping personal laws aside, okay? Just take away personal laws. Let's just not talk about it. So uniforms civil code, right, can be implemented for everything else except for personal laws. Are you okay with it? Do you support it?
Your Lordship, everything else includes?
Just anything, all the facets of society, all the laws of society into one uniform, criminal and civil. Is that so? Criminal, civil and personal is the 3 pointers that we're talking about right now, keeping personal laws aside. Are you okay with civil and criminal law getting, uniformed?
Your Lordships, criminal laws are already unified under the Code of Criminal Procedure. And Your Lordships,
civil part? The civil part?
Civil parts are also codified under the Code of Civil Procedure, Your Lordship.
Any other?
Your Lordship.
It's only about personal laws.
Transfer of Property Act, Your Lordship.
So it's only about personal laws?
Indeed, Your Lordship, because that is only an arena where civil land lacks a unified civil code right now.
Right.
Indeed, Your Lordship.
So even for penal laws, criminal laws also, different religion had different system, right? Like Sharia law is different from the Hindu law of the criminal administration, criminal justice administration. But we unified that, right? Through Indian Penal Code or Criminal Procedure Code. So why do you think that this is not a feasibility for having a unified civil code, unified legal code?
Your Lordship, crime is something that is very different from marriage, inheritance, and stuffs of those matter, because crime involves affecting the thought process of the society at large. Crime will also result in loss of life. And a marriage, inheritance, yes, they are also of importance, but they are substantially less important than crime. Hence, the codification of criminal law is important, but marriage, inheritance, adoption, they are more inclined towards religion, Your Lordship. If I am a Hindu, Your Lordship, I will obviously want my culture. I marry with my culture. I would not want to get a registration done, Your Lordship.
What if you want to marry a non-Muslim, non-Hindu, or if you want to get married to someone from LGBT community? So what scope do we have for that? Are you aware of that?
Your Lordship, for marrying from a different religion, I would follow the Special Marriage Act, Your Lordship. That is already in place in Silverland. And for LGBTQ, that is the question of litigation, Your Lordship.
Fine.
Okay.
If Your Lordship is satisfied, the council seeks permission for my co-counsel to deal with issue 3, 4, and 5.
Sure.
Please.
Much obliged, Your Lordship. It was an honor.
Your Lordship, the Council seeks permission to address issue number 3, 4, and 5.
Please, please.
The Council also seeks permission to address the bench collectively as Your Lordships.
Yes, you may.
Your Lordship, the Council would be dealing with issue number 3, that is, whether same-sex marriage can be given legal recognition. Your Lordship, the institution of marriage occupies a central role in the sustenance and progression of humankind. Your Lordship, the state is not under an obligation to recognize all type of relationship. The state only recognizes those relationships where there is a legitimate state interest. And the reason for why state recognizes the relationships of heterosexual due to their activity related to procreation. Your Lordship, it is further submitted that marriage is a public institution. It falls in the outermost zone of the privacy and is thus susceptible to the highest degree of state recognition. Your Lordship, as stated by the Council for Petitioner, they have relied on the judgment of Navtej Singh Zohar versus Union of India. Your Lordship, in that particular case, the court only granted protection to the intimate and intermediate zone of privacy of non-heterosexual couples. That is, the court in that particular case only allowed the couples to form unions. And the court specifically mentioned that not all unions can be construed to given them the term as marriage. So here the question involves the legalization of marriage, which is a public institution and which falls under the outermost zone of privacy. And that particular thing was not granted by Navtej Singh Zohar in the case of Navtej Singh Zohar versus Union of India. Your Lordship, the state, if the state goes on recognizing all type of relationships, then in the near future, the practices of polygamy and incest will come to the state and demand legal recognition. So it is not possible for the state to maintain and recognize all relationships legally. The state, by decriminalizing Section 377 of IPC, have given the right and have understood the right of the homosexual couples to form unions. But those unions cannot be termed to the concept of marriage, because if the concept of marriage is allowed, legal consequences will also follow. So, Your Lordship, it is most humbly submitted that the Section 112 of the Indian Evidence Act submits that whenever there is a question of the legitimacy of a child, we have to see that whether the child was born during the course of that wedlock or not. And if the child is born after the course of wedlock, then it must be born during 280 days of such dissolution. So, Your Lordship, this law is itself an example of a law of heteronormative nature. So, there are several laws that are in existing under the heteronormative nature. And this is not because of any discrimination, but because, Your Lordship, when the institution of marriage prevails much before the codification of law. So when the codification of law was being done, the makers were well aware of the homosexuality that prevailed, but they did not think it sufficient, they did not think it of utmost importance to include it within the state's interest. It is because of the consequences that they knew would be prevailing and coming from the legalization. Moreover, Your Lordship, in the Supreme case, it has been stated that right to marriage is not a fundamental right, and this judgment is applicable to all citizens of the country, irrespective of their gender and religion. So, the claim that right to marriage is only available to homosexual couples, and this right should be granted to homosexual couple, does not stand on any footing, because this right is not even available to the heterosexual couples. The laws have been codified in favor of the heterosexual couples because it is of the interest of the state, because there is a legitimate state interest. However, if there has been being debated about the laws about the codification of laws for homosexual marriages, then again that issue should be dealt by the legislatures, not by the judiciary.
Okay, Council, so as per your understanding, whether homosexuality right now is legal or illegal?
Your Lordship, right now it is illegal.
Homosexuality is illegal.
Homosexuality is not illegal, Your Lordship. There has been decriminalization of Section 377. Homosexuality is not illegal, but homosexual marriage is not recognized legally.
Right. So as per your understanding, you cited 112 of Indian Evidence Act. You are saying that the laws were enacted. So those laws were enacted in the year 1872. Indian Evidence Act was enacted in the year 1872. It was Indian Penal Code which was enacted in the year 1860. And at that time, they were aware of the nature of the homosexuality, and that's why they criminalized it. But as a society, do you expect us to grow, to shed our notions of like outdated things, or should we just progress with making necessary amendments and the changes in the law?
Indeed, Your Lordship, changes should be made, and we should be progressing. We should be progressing with the modern mindset. But the discrimination, but they didn't criminalize it because of any discrimination. They criminalized it because of the consequences that will follow. If we will grant marriage on the basis of love and companionship, then in polygamy, in incest, in every type of other relationships which are not termed ethical, then they will also claim that there is love and companionship there also.
Yes. So what do you suggest? So homosexuality is legal right now, right? So what do you suggest that homosexual couples should just have that relationship between them, but they should not have the right of companionship? They should not claim all those. Marriage is what? Marriage is just giving legal recognition to their relationship, right? So are you suggesting that they should live in a relationship without any legal recognition, so that in future, so in the case at hand, are you suggesting that Chandler should have married to someone which was legally recognizable? Because he was in good terms and he was seeking the companionship of Monica, right? So they wanted to be with each other, but because of the legal hurdle, they are unable to get their due rights. So this is the problem. So what the petitioners are claiming is, if we give them legal recognition, then the necessary legal rights which emanates from the marriage as an institution, they will be able to avail that. But on one hand, you are saying that the homosexuality has been legalized, and then on the other hand, you say that no, homosexuality marriages are not legal. So how do you bring a harmony between the two?
Your Lordship, to make homosexual marriage as legal, just by naming it as legal, then the problems of the country will be doubled. We have to see certain changes, because through marriage, certain consequences follow. Divorce laws follows, adoption laws follows. There are laws which follows from the validation and legalization of marriage. So that laws have the legislature has the power to enact those laws. And while making any law, you have to take the advice and opinions of people in the majority. That cannot be decided in a court of law, Your Lordship.
So if that is the case, then homosexuality should have been legalized by an act of legislature. But we went ahead and we did that, right? We legalized homosexuality in spite of the statutory mandate, in spite of the so-called will of the people. But because the situation demanded, because the course of justice demanded, we went ahead, we just decriminalized something which was there in the statute book. So are you saying that that was wrong? If that is right, then why should not we take another step and legalize same-sex marriages also?
Indeed, Your Lordship. Your Lordship, the law has been, yes, indeed, homosexuality has been decriminalized. But if we go to the ground reality, people still face discrimination. So it is obviously we have to do everything on papers, but before that we need to change the mindset of the people. So unless and until we don't change the mindset of the people, unless and until we don't unless and until the society doesn't view it as a acceptable thing, then changing the law would merely be on the paper. Same discrimination they will be facing. So there is no point in making it through the court. I agree. The council agrees that obviously the court has the power, and the court will the process has to be done by the court. But before that, there are steps that needs to be followed. People
So
are
aware. So when integration and acceptance by the society reaches a level, that the satisfactory level that you are talking about, then it's okay. Then we can do what is to be done, right? Can we legalize?
That would depend upon the facts and circumstances of that present scenario. Currently, we are not in a position to legalize those things because our laws are, we have to amend those laws, and those laws are not amendable in a short span of time. Moreover, marriage is not a fundamental right. It is not even given to the heterosexual couples. So they can't claim that we are Article 14 is getting violated because marriage is not even available. Not a fundamental right to heterosexual couples as well.
Right. So move on to the next issue, right?
Indeed, Your Lordship. Your Lordship, the next issue is whether adoption can be available to same-sex couples. Your Lordship, Section 3 of the Juvenile Justice Act directs the central and state government to follow certain principles while implementing the provisions of the Act. The principles, some of those principles are principle of best interest and principle of family responsibility. Your Lordship, Regulation 5(3) of the Adoption Regulation Act states that married couple having 2 years of stable marital relationship can adopt a child. So the intent of the Central Adoption Regulation Authority to put this provision is to provide a stable household to the child in pursuance of his best interest. Your Lordship, the principle of family responsibility that is given under the Section 3 of Juvenile Justice Act also can also be applied to the SARA regulations. So the children adopted by a homosexual couple might face social stigma and might not get access to a good family background. Your Lordship, and as stated by the counsel for the petitioner, that they stated that in section 57, it does not prohibit unmarried couple from adopting. Your Lordship, section 57 clause 2 of Juvenile Justice Act states that in case of a couple while adopting, the consent of both spouses is required. The word spouses itself means that the consent of a husband and wife is required. The thing on which they have relied is the judgment of Supreme case. That opinion of Justice Chandrachud that the word spouse cannot be termed the word spouse cannot be meant to only husband and wife. That is his individual opinion, and that is a minority judgment. So we cannot change the law. We cannot change the law on the basis that his thinking is of the context that the word spouse does not mean married couples. The word spouse means married couples. We cannot say that couples who stay together or are in a live-in relationships means spouse. So Article 57 Clause 2 mandates the condition that married couples are only allowed to adopt. Moreover, the counsel for the petitioner submitted that they are being violated. The Article 14 of in Constitution of Silverland is violated. Your Lordship, they stated that the classification is based on sexual orientation. However, the classification is not based on sexual orientation. Your Lordship, in the Adoption Regulations Act, the classification is based on the marital status of the persons seeking to adopt. So there is no discrimination on the basis of sexual orientation or gender. The classification is based on the marital status, and the rational nexus which it seeks to achieve is that it classifies the relations. It classifies couples as married as or non-married because it's sought to achieve the object that the child must be provided a stable home and a good environment. So in case of unmarried couples, the child, there is always a risk. In living relationships, in unmarried, I'm not denying that there is no law, but they cannot provide a stable household, but there is a risk. And a child who has faced adoption, who is going to be adopted, it means he has been either left out by his original biological parents, or he has been never seen his parents. So he is already under the trauma. So he needs a family with a very secured environment. So he cannot be put in a position with unmarried couples where there is no stability of the relationship. That is why this classification has been done. This classification has not been done on the basis of sexuality or gender. So the test of reasonable classification is allowed and it is passed. So there is no discrimination. The regulation prescribed by the adoption regulation is based on the best interest of the child, and it is not violative.
So, counsel, what you're trying to say is, because of the sexual orientation or because of some notions which you have that they may not be able to raise a child properly, so homosexual couples should be deprived of their right to enter into a marital relationship, and then consequently be deprived of the legal rights which arise from marriage. And secondly, they should also be derived to right of parenthood just because of the sexual orientation. Ultimately, we are doing that.
Your Lordship, in no way the council submits that they have been denied on the basis of sexual orientation. The petitioner
what option does a homosexual couple or a homosexual person has to raise a child as his own?
Your Lordship, neither, it is not about homosexuality or heterosexuality. A heterosexual unmarried couple also cannot raise a child. So there is no discrimination on the basis of sexual orientation. There is a classification based on the marital status.
Heterosexual couple, they can procreate as well as they can adopt, right? But homosexual couple, if we are talking about two belonging to the same gender, like two lesbians or two gays, in that case, they don't have the option of procreation. And secondly, you are also saying that we should deprive them of their option of adoption. So we are basically saying just because a person is lesbian or gay or belonging to this community, he should not enjoy the happiness of parenthood.
Your Lordship,
do that.
The adoption regulations that has been based, it is not based, we are not stating that they shall be denied adoption rights on the basis of sexuality. Even the adoption regulation is they have challenged the adoption regulation. The adoption regulation is simply stating that unmarried couples have no right to adopt. It is not talking about sexuality or gender orientation. Unmarried heterosexual couples also don't have any right to adopt. So here there is no discrimination on the basis of sexual orientation or gender, my Lordship. The regulations are made on the keeping in specified interest of the child, your Lordship. Of the child that needs to be adopted. It is not about the sexual orientation and gender, your Lordship.
As per your argument, do you agree that a single divorced mother who has custody of a child, adopted child, they adopted while they were married and then they got divorced, right? See what's the interest of the child, whether it will be hampered with that single divorced mother? will she not be able to raise him or her properly? Are you getting my
No.
question?
Yes.
Same with the
That
case of heterosexual marriages, custody of a child with the mother or the father after divorce, right?
indeed,
Only one gender raises them.
indeed.
Shikhar Dhawan, have you read that?
Indeed.
The custody of the child is with,
The
present the child is with his wife, right?
mother. Yes.
So whether he's getting the right treatment or not, what's happening?
Your Lordship, as per the case that you have stated, it means the child has already developed a bond with both the father and mother.
So why not
So,
the homosexuals a chance to develop the bond with the adopted child?
because that right is not even allowed to heterosexual unmarried couples. That is the council is talking about the law. The law is denying the right to both heterosexual unmarried and homosexual unmarried. It is not at all speaking about the homosexual couples.
Right, the interest of the child in general, right? The interest of the child. This scenario, as I just presented before you, right, is similar to what would happen if homosexual couples adopt. Is that correct? It's more or less similar.
Your Lordship, that would depend on the facts of circumstances of the very particular case. But in general, notions, if we see, then obviously we have marriage is a security. Unmarried couples don't have the security, even if they are heterosexuals. So that keeping that in mind, they have framed the laws.
So that is more the reason that we should allow homosexual couples to marry. If you are saying that heterosexual unmarried couples cannot adopt, but heterosexual couples have the option to get married and then adopt a child, right? But homosexual couples don't have that option. So we should allow marriage as an option to them so that this adoption can be allowed. Are you okay with it?
As I stated before, Your Lordship, that takes time. It can't be done through one. We need awareness. Even if the child let us take a scenario, even if the child is placed with the homosexual couples, whether married or non-married, will the child be able to face the social stigma? Will the child be able to face, will the child be able to go to school and not face any discrimination? So then the child will feel harassed. What's the point of giving? What's the point of being and getting harassed and discriminated everywhere? That is my sole point. That is my point, that why same-sex marriage is cannot be applicable at the current scenario, because we have to change the mindset of the people first.
But
And
if we
that
bring
has
in
to
a
be.
law, council, if you bring in a law, if we allow homosexuals to get married, then okay, it may be a cause of stigma for 1 or 2 persons because it will be a unique thing in a school or in society. But gradually, if the law is allowed, then this thing will get acceptable. Or are you saying that we should accept for the society to start accepting these things and then we'll bring in a law?
No, there should be a balance. I'm not saying the whole of the society will accept, then we will bring the law. There should be a balance, I accept. But merely bringing the law will be of no result, because, Your Lordship, there are also provisions for punishment for crimes. Are there not happening any murders? Are there not happening any rape? So merely bringing the law it doesn't guarantee that we will be secured. We have to see and proceed forward.
Awareness, right?
Yes, indeed, Your Lordship.
Okay. Next, move on, right?
Indeed, Your Lordship. So if the Lordship is satisfied with issue number 3 and 4, the council would like to state issue number 5.
Okay. As your time is over, just try to sum it up within 2 to 3 lines. Okay.
Indeed, Your Lordship. Your Lordship, the petitioners have filed the PIL for recognition of same-sex marriage and adoption. But by adding the issue of disbursing the death benefit by the LIC, they are including the private interest, which is again opposed to the concept of PIL. Under the amendment made to the Insurance Act, section 39 states that who can be the beneficiary, and in their beneficiary are father, mother, spouse, and children. All right. So and again, if the counsel for the petitioner submitted that submitted the concept of insurable interest. So if we go by that concept, it is observed that insurable interest is allowed to relationship of marriage, blood, or adoption. Monica is related to Chandler neither by blood, neither by adoption. So by allowing this issue to be adjudicated upon this under this PIL, we will recognize their marriage because they are going through the concept of insurable interest, which is the question of the litigation. So this issue shouldn't be allowed to be adjudicated in the present PIL. That is my submission.
All right.
So, Your Lordship, the Council seeks permission to submit the prayer.
Please.
Your Lordship, therefore, in the light of the issues raised, arguments advanced, and authority cited, it is humbly prayed to the Honorable Court that to declare same-sex, to reject the application for to reject this PIL and to not declare same-sex marriage as valid, to not to reject the PIL claiming the disbursement of death benefit claim by the LIC, and pass any other order that this honorable court may deem fit in the interest of justice, equity, and good conscience, for which the respondents are in duty bound shall ever pray.
Okay.
It was a pleasure to argue before this bench, Your Lordship.
Thank you.
It was a pleasure to hear you all.
Yeah.
Well, good presentation, everyone.
Great topic, by the way. The overall topic is the most important topic that should make headlines for a year, but unfortunately it's not these days, right? It has died out. It has died out post the Supreme Court judgment. Okay. Thank you.
Thank you. Thank you, Your Lordship.
Okay. Can we have the other two teammates also on screen? I would just like to give 2 to 3 inputs so that it helps you in future. Okay, this moot court is fine. You all did very well. Okay, so I'm very much impressed by all your presentation, and the standard of mooting has increased. Okay, I'll give a certificate on that. Okay, all of you were very good. Just 2 to 3 suggestions which I would be giving, which will be good for all of you. Number one, whenever you are coming for mooting, because mooter number 1 of the petitioner, I asked you certain questions which you are actually which should have been asked to mooter number 2. So when you are coming for moot, you should be having a brief idea of other issues also. Okay, you can say that the details of this issue will be dealt with my co-counsel. You have that option. That's a different thing. But you cannot just say that, no, this is something which is to be dealt with my co-counsel. And if you are complete ignorance about those issues, that means that you're completely not thorough with the whole case of yours. Okay, so whenever coming prepared, so make sure that you have an overall idea of all the issues and stick to your issues and have a detailed research on those issues, but you should have a general idea of all the issues. Okay, number one. Number two, any jurisdiction in any moot court, criminal or civil, you should also know the related jurisdiction. For example, if you're coming before under Article 32, you should also have a brief idea about the Article 226. Okay, so the constitutional provisions which are in play, that should be thoroughly researched. Okay. So this is a brief idea, and then this is about the question. And then another thing, when you are giving any citation, you should also have a brief idea that what this particular case was relating to, because petitioners said they were completely harping on a particular case law, but you should also have a brief idea. Obviously, if you are citing 5 laws, 6 laws in memorandum, you are writing 10 case laws, then you are not aware. We cannot expect you to be aware of all the case laws, but at least you should have a brief idea, and especially of those cases which you are citing in your oral submissions. So you should have a brief idea about those the brief facts of this of that case. Okay. Then secondly, I would like to say that some of the questions were very well answered, which was beyond my expectation. Okay, very well answered. But yes, I would definitely like to say that especially in moot courts, a more submissive approach is appreciable. Okay, especially I would like to say about respondent number mooter 2 of respondents. She was very brilliant in answering questions. She in fact answered every question in the best manner possible, but we would expect that your answer should be more submissive, because you are not arguing with the judges, right? Or you are not like, it's not a random argument with the, and especially with, I will just give you an example. When you're citing Justice Chandrachud, Okay, he's the Chief Justice of India, so you cannot say that he said that, he said that. No, his lordship said this. You can counter it. It is within your right. You are a counsel. You can counter it. You can counter the bench also. But first of all, when you are asked a question, it would be better if you say much obliged, your lordship. Then you keep answering the question with a tone of politeness and submissiveness, which was there in other councils. She was best in answering the answers. So the point of this mooting is we should all learn from each other's strength. Okay, so petitioner mooter number 1 and respondent mooter number 1, they were very submissive and their presentation was very nice. But petitioner respondent mooter number 2, she was very good in answering questions, but a better tone of submissiveness and humbleness will make you a better mooter and a better advocate also. Okay, because some of the judges may not like the tone. Okay, but you were very good. I'm not saying that your tone was bad or it was not submissive at all, but you can improve on that area. And respondent number 1, Mooter, she was brilliant. I must say, we all must learn that she was very thorough with the laws as well as the presentation. So it was a very good thing, because when you are coming prepared for the moot court competition, judges should learn a thing or two from you, because you are researching on that problem for months together. But the judges, they are coming to the event for their experience. They are not that much thorough with the problem in hand. So your different, because she was covering TP Act and Insurance Act, so all those things were covered. So that is a very good thing. And she was also like the questions, the answers which were given by her to questions were supported by case laws or were examples, because one question I asked, then she gave me an example of a Special Marriage Act. So that is appreciable. That shows your knowledge of law. Okay, so when you're trying to answer, because while mooting also you're getting a chance to show your knowledge of law, but while answering also, if you're if you have something in mind which you think that no, I was unable to present that during the course of my argument, so even while answering, if you get an opportunity to do that, then you should do that, which was done by respondent mooter number 1. And as far as petitioner side is concerned, petitioner mooter number 1, you are very good. But as I said, just you should be thorough with the basic laws and case laws which you are presenting, because knowledge of law is an important part. You are a very good mooter as far as your presentation is concerned. You are very submissive. Your modulation was very good. Everything was fine. But when you are coming for mooting, then a little edge and little extra, at least the ancillary, we don't expect you to come with the knowledge of all the laws, but the basic laws which are at play in the moot court problem, you should be aware of that. And for mooter number 2, you were also very submissive and very humble, but a better modulation in your tone will make you a better mooter, right? Because you are saying in a particular rhythm, which was very soft spoken. That is appreciable, no doubt. But for some points, you need to give emphasis, right? So you will have to change your tone for that. You will have to bring some impact on that particular statement which you are saying, because if saying in a monotonous tone, that it is not giving the impact to the points which are otherwise impactful. We were like listening to you on this like VC, and we are completely paying attention to you. So that's why we are able to hear your points and appreciate your points. But in a courtroom, the judges will be having so many other distractions. They will be sitting, another judge will be sitting by, there will be other advocates who will be coming and going. Sometimes they will be listening for long hours. So you will have to give some impactful performance. Otherwise, if you are speaking, you will be making some good points, but it will get omitted. It will not be heard by the, it will be ignored by the concerned judge. It may so happen. So that voice modulation will be appreciable. Okay. So these are the things on which you can work upon. Okay. So all the very best. It was very, very, very nice hearing you all. Okay, and I'm in awe with all of your presentation. You all were unique in your own ways, but these are certain things which we'll learn from other co-mooters. Okay, so then we'll be the best mooters in our level. Okay.
In a division bench, generally the junior judge is not supposed to speak a lot. Words of wisdom by my senior brother. I mean, please take it, please implement it. And sir, just the questions that sir asked, it is of the best of quality, and I hope you will expect the same in the next rounds, right? Or more or better. So I wish you all the best, right? Thank you.
Thank you, Lordships.
Thank you.
Thank you, Lordship.
Thank you, Lordships.
Excuse me, my Lordships, there was supposed to be a rebuttal round as well.
Yeah.
Okay.
Thinking about that. The petitioner's side, right?
Yes, my Lordship.
Your Lordship, the council would seek the permission to go for the rebuttal.
Please.
Yeah, please.
Much obliged, Your Lordship. Your Lordship, it is contended in para 9 of the respondent that memorandum states that Shahabano Begum case and Shaira Bano case have increased the sentiment of fear among the Muslim community. What is the basis of such contention? And that because this kind of contention challenges the very astuteness and acumen of the judiciary, and indeed it's a contempt of court. The Lordship, for the para 20 of their memorandum, invokes section 112 of the Indian Evidence Act into the whole thing, which has no relation with the present case. Your Lordship, para 4 of the respondent's memorandum states that the petitioners have approached the jurisdiction of Honorable Court for the recognition of marriage that involves private interest. The argument stands without any validation because para 8 of the proposition is for recognition of same-sex marriage, which vindicates larger public interest of the LGBTQ community. Your Lordship, lastly, if the satisfaction of society has to be taken for legalizing same-sex marriage, then perhaps untouchability would never have been abolished. That's it, Your Lordship. And it was an honor to argue before this court.
The rebuttal from both the sides are appreciable. The respondents, during your course of submissions, you were like aware of what new points they were bringing, so that is appreciable. And I would also like to appreciate the petitioners because they actually took out some important points and they presented a rebuttal on that. Okay, very good. This is very much required in advocacy. Okay, rebuttals. So, anyways, all the best.
Your Lordship, we answer the questions of the petitioner.
Okay.
Pardon? You want to
answer?
Sir, rebuttal? Okay, fine.
Indeed, Your Lordship. Your Lordship, the petitioners stated that para 8, which was the answer to the question of litigation, Your Lordship, and para 4, it was the statement of argument, Your Lordship. That was what the respondent wants to state, and para 8 is the answer to the question of litigation, the issues. Sorry, Your Lordship.
Okay.
Much obliged, Your Lordship.
Okay, organizers, can we take leave?
I extend our deepest appreciation to all our esteemed judges for their invaluable contribution and insight. Your guidance has not only enriched our competition but has also left an indelible mark on the minds of our participants. We are immensely grateful for our generosity in sparing your valuable time for us. Thank you.